Imagine, right? You have just paid £2 million for this prime, totally unique piece of real estate right in the heart of London.
Oh, wow. Okay. Setting the scene.
Yeah, I mean, you sign the contract, the ink is completely dry, and you are literally popping the champagne.
Right, because you're scheduled to get the keys tomorrow.
Exactly. But then the phone rings. It's the seller. And they just casually mention they got a better offer from some international buyer for $3 million.
Ouch.
Yeah. So they are backing out. They just aren't going to sell it to you anymore. So, like, what do? Do you just get your deposit back?
I mean, that's the big question, isn't it?
Right. Or, like, can you force them to hand over the land, or do you get that extra £1 million they just made off your property?
It is basically the ultimate legal nightmare.
It really is.
And honestly, it exposes this fundamental misunderstanding that most people have about the law.
What do you mean?
Well, we tend to view a contract as this, magical, unbreakable spell.
Right. You sign it, and it's set in stone.
Exactly. You assume it's a permanent, immovable fixture of reality. But the reality of commerce and, frankly, human nature is that things are rarely permanent.
That is so true. People change their minds all the time.
Promises get broken, circumstances change, disasters strike. The law doesn't exist in this vacuum of perfect promises.
Yeah.
It exists to manage the messy reality of what happens when things completely fall apart.
Which is exactly our mission for this deep dive.
Absolutely.
For you listening, whether you are in the trenches cramming for your SQE1 exams, or you just, want to understand the invisible rules that govern literally every purchase and lease in your life.
Which is everyone, really.
Right. We are tearing apart a stack of revision material on contract law today, specifically Part 3.
The fun part.
The really fun part. We are looking at the life cycle of a contract after it's born. We're going to uncover how contracts naturally die, how they mutate, and how the legal system steps in with a mop and bucket when they are just shattered.
It's a fascinating journey, I think, because we are moving away from the pure theory of how a contract is formed.
Formation is so neat and tidy.
Right. It's offer, acceptance, consideration. You're just building the ship.
Yeah.
But today, we are launching that ship into the open ocean of the real world.
Where it has to survive storms and mutinies.
Exactly. We are looking at discharge, variation, and remedies.
Okay, so let's unpack this, starting with the baseline. Before we can talk about fixing broken contracts, we have to understand what it means for a contract to simply end.
Right.
And in the legal world, this is called the discharge of a contract. Now, legal terms can sometimes feel like this totally foreign language designed to confuse us.
They really can.
So what exactly does it mean mechanically to say a contract is discharged?
It's actually an incredibly elegant concept when you break it down.
Okay.
To put it simply, discharge means that the parties no longer have to perform their contractual obligations.
Like all?
At all. The contract has reached the absolute end of its life. It's finished. The invisible legal chains that bound those two parties together are severed, and both are just free to walk away without looking back.
There is a really fantastic memory trick for this in the source material, especially if you are sitting in a stressful exam hall trying to recall the exact definition.
Oh, the hospital one.
Yes. Think of discharging a patient from a hospital. I absolutely love this analogy.
It works so well.
Right? Because just like a patient who is admitted to the hospital, they are undergoing treatment. They are subject to all the strict rules of the ward.
They have obligations.
Exactly. They have to stay in bed. They have to let the nurses draw blood. They have to take their terrible medicine. They are bound to that institution.
Right.
But once they are cured, the doctor signs the paperwork and they are officially discharged.
They get to leave.
They are free to walk out the front doors, get in their car, and just go back to normal life. The contract is cured or finished, and everyone is released from any future obligations.
What's fascinating here is how perfectly that analogy captures the sheer sense of release. In a contract, your sickness, so to speak, is your obligation. It's a burden.
You owe something to someone.
Exactly.
Right.
You owe them £1,000, or you owe them 10 hours of consulting, or a shipment of steel. That is a weight on your shoulders.
Yeah.
Once the contract is discharged, that burden is entirely lifted. You are legally healthy again, totally free of that specific burden.
That makes perfect sense.
And for a rigorous exam like the SQE, you really need to understand the mechanics of the four main ways a contract can reach this state of discharge.
Okay, let's go through them systematically then. Number one is the most obvious and honestly the most ideal way. Discharge by performance.
Yes. Performance is the gold standard.
It's what you want to happen.
Exactly. It's the easiest to understand because it is exactly what you hope for when you enter into the agreement in the first place.
Everyone does exactly what they promised to do.
Right. You promise to pay £1,000 for a custom-built laptop, you transfer the money, and they hand over the laptop. The transaction is complete.
The contract is discharged by performance.
Job done.
So, if I hire you to paint my house and you paint my house perfectly and I pay you the agreed amount, the contract is just dead.
Yep. Neither of you owes the other anything anymore.
We can just shake hands and wave goodbye forever.
Precisely. The obligations have been fulfilled to the absolute letter, and the entire legal framework of contract law is built to encourage this exact outcome.
Because the economy needs it to.
Right. The global economy relies on people actually doing what they say they will do. But, and this is big, but I should note that the law here is incredibly strict.
Okay, how so?
The performance usually must be exact and complete.
Wait, hold on. Let me push back on that a little bit. What do you mean by exact and complete?
Well,
Like, what if you painted 4 out of the 5 rooms in my house and then you just got tired and went home? Have you performed the contract? Like, do I have to pay you for the 4 rooms?
this raises a really important question, and it is a classic trap for students on exams.
Oh, I bet.
Under the strict common law rule, which is often referred to as the entire obligations rule, if you promise to do a complete job for a lump sum, you don't get a penny until the job is completely finished.
Are you serious? Not a penny.
Not a penny. If I paint 4 out of 5 rooms, I have not performed my obligation exactly and completely.
Wow.
Therefore, the contract is not discharged by performance, and strictly speaking, you wouldn't owe me the agreed price because I breached the contract.
That seems incredibly harsh.
It is hard.
You put all that work and all that expensive paint into 4 rooms, and I just get to keep the benefit for free because you missed the hallway.
It is very harsh, which is why the law has developed some exceptions over the centuries.
Okay, good.
Like the doctrine of substantial performance, where if the defect is, very minor, you might get paid minus the cost of fixing the defect.
Right, like deducting the cost of the hallway.
Exactly. But the baseline rule you absolutely must remember is that performance must be precise. You cannot deliver 999 widgets when the contract called for 1,000 and claim you performed. You just didn't.
That is a brilliant nuance to keep in mind for anyone taking the test. Exact and complete.
Always.
But of course, we don't live in a perfect world where everyone finishes the job perfectly.
Definitely not.
Which leads us to the second method of discharge, which is agreement.
Right. Discharge by agreement. This just means that both parties can simply look at each other and agree to end the contract early before performance is complete.
And there's a really beautiful symmetry to this when you think about it.
What do you mean?
Well, contracts are born by agreement, right?
Right.
2 people come together, their minds meet, and they create this binding legal bond out of thin air just by agreeing to it.
Exactly.
So logically, they should be able to dismantle it the exact same way.
Yeah.
They agreed to create it, so they can agree to destroy it.
I love that framing. If we connect this to the bigger picture, it really highlights one of the core philosophies of modern contract law,
Which is
freedom of contract. The law deeply respects the autonomy of the parties.
Yeah.
The law doesn't actually care about your house getting painted. It only cares about enforcing your will.
That makes sense.
So if you and I enter into an agreement and halfway through we both realize it's just not working out, maybe your financial situation changed, or maybe I got a better job offer. The law isn't going to stubbornly force us to continue.
And just steps out of the way.
Exactly. If we both say, let's just call the whole thing off, the law steps back, nods, and says, fine, you are both discharged.
It's basically like a mutual, highly amicable breakup.
Exactly like that.
Nobody is at fault. Nobody is angry. Both people just realize it's better to walk away, and they release each other from the relationship.
Yeah.
No hard feelings.
Yes. But the key word there is mutual.
Ah, okay.
One person cannot just wake up, declare the contract over by themselves, and call it an agreement.
Right, because that's just breaking a promise.
Exactly. That is not a discharge by agreement. That is a repudiatory breach of contract, which we will get to later. Both sides must actively consent to release the other. In legal terms, you are basically exchanging promises not to sue each other for failing to finish the original contract.
And that exchange of release is what kills the contract.
Precisely.
Okay, so performance and agreement are very neat. They are tidy. Everyone is on the same page, acting reasonably.
Right.
But here's where it gets really interesting. Because what happens when unexpected, massive chaos strikes.
Oh, this is the best part.
Right. We move from the predictable world of people doing what they promised into the completely unpredictable, messy world of real life.
Yes, we do.
This brings us to the third way a contract is discharged, which is the doctrine of frustration.
Frustration. This is a concept that law students often find incredibly confusing because the name sounds like an emotion.
Yeah, like you're just annoyed at the contract.
Right, but it has nothing to do with being annoyed.
Okay.
Frustration happens when something totally unexpected occurs after the contract was made.
Okay, after it was made.
Right, and this unexpected event does one of two things. It either makes performance completely impossible, or it makes performance fundamentally radically different from what the parties originally agreed to.
Okay, let's slow down and really look at the mechanics of this, because this is where the dry theory hits the pavement.
Let's do it.
A classic scenario from the sources that comes up all the time is a concert venue burning down.
A perfect example.
So let's say I'm a massive concert promoter. I've rented your beautiful, historic 19th century theater for a massive rock show next month.
Okay, I own the theater.
We have an ironclad contract. I've agreed to pay you £50,000. You've agreed to provide the venue, the security, the lighting.
Sounds like a great deal.
Right. But tonight, a freak lightning storm hits, and the theater burns to the absolute ground.
Oh, no.
There is no theater anymore, just a pile of smoldering ash.
Right. In that scenario, performance is literally physically impossible.
Yeah, obvious.
You cannot hold a rock concert in a pile of ashes. Neither of us planned for this. There was no clause in the contract saying what to do if the building ceases to exist.
Nobody writes that into a standard contract.
Exactly. It happened after we signed the contract, so we couldn't have accounted for it. The law looks at this situation and says the contract is frustrated.
It's just gone.
It is instantly discharged. The obligations are wiped away because the universe intervened and made the contract impossible to fulfill.
Wait, hold on. I'm the promoter in this scenario. I've already sold 10,000 tickets. I have a band flying in from Los Angeles.
I know, it's a mess.
I can't just walk away.
Nah.
I might say to you, look, clear the ashes, put up a massive festival tent on the dirt, and we'll hold the concert outside.
Right.
Or I might say, you owe me a venue. Go rent the arena down the street for me. Why doesn't the law force you to find a workaround?
Because that would be forcing you into a fundamentally different contract.
Ah, I see.
Our contract wasn't for a tent in a dirt lot, and it wasn't for the arena down the street. It was specifically for that historic 19th century theater.
That exact building.
Yes, the specific subject matter of the contract has been destroyed. The law is very pragmatic here.
How so?
It recognizes that holding you to an obligation that is physically impossible or forcing you to perform a radically different obligation that you never agreed to is just absurd.
Yeah, that makes sense.
The contract dies the moment the building collapses.
So if the subject matter is destroyed, you can just walk away.
Yeah.
But, I mean, what prevents people from using this as a giant loophole?
What kind of loophole?
Like, let's say I'm a factory owner in London, and I've agreed to supply you with 1,000 custom steel widgets for a set price.
Okay.
But suddenly global supply chains collapse, the price of raw steel skyrockets by 500%, and now I'm going to lose an absolute fortune on our deal if I fulfill it.
A very common scenario.
Can I just call you up and say, oh, the market changed unexpectedly. It's economically impossible for me to survive this. The contract is frustrated. I'm discharging myself.
Well,
Because that seems like it would destroy the entire point of signing a fixed price contract in the first place.
this raises a very important question, and you are hitting on exactly why the courts keep the doctrine of frustration on a very tight, very short leash.
Okay, so they don't just let anyone use it.
Absolutely not. Frustration is not a get-out-of-jail-free card just because you made a bad bargain or the market turned against you.
Right.
If a contract just becomes more expensive, more difficult, or less profitable to perform, that is your problem.
That's just business.
That is the exact commercial risk you took when you signed a fixed-price contract.
So the court will look at me, bankrupting myself to buy this expensive steel, and say, too bad, keep making the widgets.
Exactly. Economic hardship is almost never frustration. Frustration requires the performance to be impossible or fundamentally radically different in nature. It cannot just be the same performance made more expensive.
Right.
Another classic example of true impossibility is the destruction of specific goods.
Like the theater, but for items.
Exactly. If you agree to buy a specific one-of-a-kind original painting by a famous artist and a flood destroys it in the warehouse before delivery, That is impossible. You can't just substitute another painting.
Now, what about situations where things don't burn down or get flooded, but the law itself changes?
Oh, supervening illegality.
Right. I've seen scenarios in the notes about this.
Right.
Let's say we have a 5-year contract where you import a specific industrial chemical for my manufacturing plant.
Okay, standard commercial deal.
2 years into the contract, the government passes emergency environmental legislation banning the import, sale, and use of that exact chemical because they discover it's highly toxic.
That is a textbook case of frustration by supervening illegality.
Because it's illegal now.
Right. When we signed the contract, it was perfectly legal. But now, if you were to continue supplying me, or if I were to continue paying you for it, we would both be committing a crime.
And a judge won't force you to commit a crime.
Exactly. You cannot be contractually obligated to break the law of the land. So the exact moment that legislation comes into effect, the contract is frustrated.
It dies instantly.
It dies instantly, regardless of what the parties want.
Even if we both desperately want to keep doing the deal in secret, the state steps in and kills the contract.
Precisely. And then there's one final, very tricky category of frustration.
Oh, what's that?
It's when performance is physically possible and strictly legal, but the entire underlying purpose of the contract has vanished.
The purpose vanished. How does that even work?
Think about renting a balcony overlooking a specific street in London. Why would you pay an exorbitant amount of money to rent a balcony for just one afternoon?
Usually because there's a parade, like a royal coronation or something.
Exactly. The famous historical cases involve exactly that. People rented expensive rooms to watch the king's coronation procession pass by.
Right, the coronation cases.
But then the king fell terribly ill and the parade was canceled at the last minute.
Oh, wow.
Now, technically, the contract isn't physically impossible to perform. The room still exists. The balcony is there.
You could still go sit on it for the afternoon if you wanted.
And it's not illegal to sit there. But the courts ruled that the contracts were frustrated.
Why?
Because the absolute sole foundation of the agreement, the fundamental purpose both parties understood, which was watching the procession, had evaporated.
The whole point of the money was the parade.
Exactly. To enforce the contract and make the person pay for an empty room overlooking an empty street would be a radically different bargain than the one they signed up for.
That is fascinating. So frustration can be physical destruction, illegality, or the complete destruction of the shared purpose.
Yes.
But there is a massive caveat here in the notes, isn't there? A core memory tip that governs all of this. And it is incredibly important for anyone analyzing a scenario for an exam.
Yes, very important.
You have to ask yourself a very specific question when assessing frustration. Whose fault is it?
Yes. The golden rule for frustration is no one's fault.
No one's fault. Okay, let's test this. Let's go back to our burning concert venue.
Huh?
If a random freak lightning strike burns it down, that's an act of nature.
Yeah.
It's an act of God. No one's fault. Frustration applies. I walk away, you walk away.
Correct.
But what if I, the venue owner, was careless? What if I decided to host an indoor fireworks display the night before?
Oh, boy.
Or, like, I actively ignored a massive electrical fault that the fire department warned me about, and that negligence caused the fire.
If somebody caused the problem, if it is self-induced, it is never frustration.
Never.
Never. It's a breach of contract. If your active negligence or your deliberate choice destroyed the venue, you cannot hide behind the equitable shield of frustration to escape your obligations to the promoter.
Because I caused the impossibility.
Exactly. The law requires a strict standard of innocence here.
So if I burn down my own venue through stupidity, I am on the hook for all the promoter's lost ticket sales and wasted expenses.
Absolutely. Frustration is reserved exclusively for those truly out-of-the-blue, unforeseeable external events that neither party had any hand in causing.
That makes total sense.
It's a mechanism for fundamental fairness, acknowledging that sometimes, despite everyone's absolute best intentions and careful planning, fate simply intervenes and makes the contract unworkable.
It balances the rigid strictness of commercial law with basic human reality. You shouldn't be penalized and bankrupted for a random lightning strike, but you absolutely should be penalized for burning down your own building and ruining someone else's business.
Perfectly said.
Which brings us to the fourth and final way a contract can end. Breach of contract.
Indeed. If a contract isn't discharged happily by complete performance, and it isn't ended peacefully by mutual agreement, and it isn't frustrated by some dramatic outside event,
but someone just simply fails to perform their side of the bargain.
Or outright refuses to do so. That is a breach.
They just don't do what they promised, or they do it terribly.
Exactly. And depending on the seriousness of that breach, whether it goes to the absolute root of the contract or is just a minor issue, the innocent party may have the right to officially terminate the contract entirely.
Effectively killing it.
Yes. This discharges the contract, bringing the primary obligations to an end, but in a very violent, messy way.
Leaving behind a trail of legal consequences that we will explore deeply when we get to remedies.
We definitely will.
So just to lock this fundamental framework in for you listening, think of it as the 4 exits from the highway of a contract, the 4 methods of discharge.
A great way to visualize it.
1. Performance. We reach the destination. We do what we said. 2. Agreement. We mutually agree to pull over and walk away. 3. Frustration. A meteor hits the highway and makes the journey impossible, through no one's fault. And 4. Breach. Somebody purposefully drives the car into a ditch.
That is the complete baseline. That is the life and death of a contract.
It is a very comprehensive framework. But, as you alluded to earlier, not every change in circumstances leads to the death of the contract.
Right. Sometimes the parties are heavily invested.
They want to keep the relationship alive, they want to finish the project, but they desperately need to adapt to new realities on the ground.
Which perfectly transitions us into the concept of shifting sands.
Yes, we've seen how a contract ends. But imagine you are a massive construction firm and you are 2 years into a 5-year contract to build a skyscraper.
A massive undertaking.
The contract is 1,000 pages long. But the realities of the global supply chain, labor availability, and material costs have completely shifted since you signed it.
As they always do.
Both the developer and the builder decide they'd like to change the agreement without throwing the whole multi-million-pound deal in the bin.
Right.
The obvious question is, can they just change it? And the answer is absolutely. This legal mutation is called variation.
Variation is incredibly common. It's almost ubiquitous in long-term commercial life.
Yeah, I'd imagine so.
A variation simply changes the existing terms of a live contract. The scenarios are endless. Maybe the final delivery date for a software system needs to be pushed back by 6 months because the client changed their requirements.
Or the unit price of manufactured goods needs to increase.
Exactly, to reflect a massive spike in raw material costs. The scope of the work might expand to include a new building wing, or it might shrink. Or perhaps the payment schedule shifts from a lump sum at the end to monthly installments to help with cash flow.
It sounds so simple and pragmatic. Business moves fast. You get on a Zoom call, you say, hey, can we push delivery to Friday instead of Tuesday? The other person says, sure, no problem. You cross out a date on the paper and write in a new one or shoot over a quick email confirming it.
Right. If only we were that simple.
It's not.
This is exactly where businesses get themselves into massive legal trouble and where students consistently lose marks on the SQE exam.
Oh.
The crucial question you must always ask when analyzing these scenarios is this variation legally enforceable?
Legally enforceable.
Yes, because a casual conversation on a Zoom call or a quick thumbs up emoji in an email agreeing to a change is very often not enough to legally bind the parties to that new arrangement.
Wait, if we both agree to the change, why isn't it binding? We literally just talk about freedom of contract.
We did.
If we can agree to end a contract, why can't we agree to just tweak it?
Because of the structural rules of contract law. A great memory trick to conceptualize this is that you shouldn't think of it as just changing a few words in a contract.
Okay, how should I think of it?
The law doesn't view it that way. You have to think of a variation as building a mini contract inside the original contract, like a Russian nesting doll.
A mini contract.
Yeah.
Okay, so I have to build a whole new legal structure just to change the date.
Precisely. The law views a variation as a brand new legal agreement that alters the old one. Therefore, this new agreement, this variation, must strictly satisfy the normal foundational rules of contract formation.
And for those revising, those 3 sacred rules of formation are offer, acceptance, and consideration.
Exactly.
Let me make sure I have this straight because I want to test this with a real-world hypothetical. Let's say I'm an independent software developer building a custom app for your business. The original contract says I deliver the final app on June 1st and you pay me £50,000.
Standard contract.
But in May, I realize the coding is much, much harder than I anticipated. I'm stressed. I'm behind schedule. I call you up and say, listen, I am drowning here. I desperately need an extra month. I'll deliver the app on July 1st instead.
Okay.
You're a nice person. You don't want me to have a breakdown, so you say, fine, take the extra month to make sure it works.
Why, I'm being reasonable.
We had a clear offer of me asking for more time. We had clear acceptance, you saying fine. Is that a legally binding variation? Have we successfully changed the contract?
What's fascinating here is that, based strictly on classic common law principles, that variation is completely useless.
Wait, really?
It is not legally binding because it utterly lacks the third crucial element, consideration.
Consideration, meaning the exchange of value.
Exactly. Consideration means both sides have to give something of value or suffer some detriment to make a promise binding.
Okay, let's look at my example.
In your example, we look at the new mini-contract. You are getting something of massive value, an extra month of time to do your job.
Right.
But what am I, the client, getting in return for my promise to give you that time?
You get the app.
But I'm getting exactly what I was already legally entitled to under the original contract. The app. I'm just getting it later, which is actually worse for me. I have given you a benefit, but you have not given me any fresh value in return.
I'm just doing what I already promised.
Yes, you are just promising to perform your pre-existing legal duty. Therefore, there is no new consideration for that change. The mini-contract fails.
So what does this actually mean for me in the real world? It means you could turn around on June 2nd, the original deadline, completely ignore your promise to give me an extra month, and sue me into oblivion for breach of contract simply because our verbal agreement wasn't a valid mini-contract.
Exactly.
Even though you looked me in the eye and promised me the time.
I could sue you, and I would likely win. Your defense of, but you promised me an extension, would fail because that promise wasn't supported by consideration.
That feels incredibly underhanded. Why does the law allow you to go back on your word like that? Why demand this strictness? Why insist on this rigorous mini-contract structure just to change a date when both people agreed to it in the moment?
If we connect this to the bigger picture, it is not about encouraging people to break their promises. It is entirely about preventing economic duress and extortion.
Extortion, how?
The law enforces the pre-existing duty rule to prevent one party from unfairly holding the other hostage halfway through a critical project.
Okay, give me an example.
Imagine a slightly different scenario. Imagine you hire a builder to build your family home. They get halfway through, winter's approaching, they take the entire roof off your house, exposing it to the elements.
Oh, it's stressful.
Then they just stop working. They call you and say, actually, materials are expensive. I'm not finishing this house unless you agree to pay me an extra £50,000 on top of the original price.
I would be completely trapped.
Yeah.
I can't leave my house without a roof in November. I would have to say yes. I would agree out of pure desperation.
Right. You have technically agreed. There is offer and acceptance. But the law steps in to protect you.
Thank goodness.
The law says, no, that variation lacks consideration. The builder is just promising to finish the house, which is exactly what they were already legally contracted to do.
They aren't offering anything new.
Exactly. They're offering no new value for the extra £50,000 because there is no consideration. Your promise to pay the extra money is totally unenforceable.
So what happens?
Once the house is finished, you can just refuse to pay the extra $50,000 and the courts will back you up.
Well, that is amazing.
The strict rules of offer, acceptance, and consideration protect vulnerable parties from being bullied by their contractual partners. You must treat every change as a serious legal event involving a genuine exchange of value.
That is such a powerful insight. Variation isn't just admin, it's a structural engineering change to the legal bridge you've built between two people.
A great metaphor.
You have to make sure the new beams are just as strong as the old ones. You need the offer, the acceptance, and the fresh consideration.
Yes.
So if I wanted that extra month to build your app legally, I should have offered to knock like £1,000 off the final price.
Exactly.
Then I get time, you get a discount, boom. Fresh consideration on both sides. The variation is legally watertight.
Precisely. Or if you absolutely cannot provide new consideration, you have to execute the variation formally as a deed. A deed is a specialized, formal legal document that requires specific wording and witnesses. And its unique power is that it completely bypasses the need for consideration.
Oh, okay.
But that is a highly formal process. For everyday business, the core takeaway for the exam is variation equals a mini-contract, and it almost always dies on the altar of consideration.
Okay, so we've looked at discharge, where things end cleanly or are frustrated by light and bolts. We've looked at variation, where we carefully legally adjust the terms to keep the ship afloat.
Right.
But now we arrive at the absolute core of the real world. If a contract isn't discharged properly and it isn't legally varied, but someone just outright fails to perform, refuses to perform, or does a terrible job.
We have a breach.
And this brings us to one of the most heavily tested, most philosophically dense topics in all of contract law: remedies.
The big one.
When someone breaks a promise, the law's main question is simply, what should happen now?
That is the pivotal question of all civil litigation. A breach has occurred. The contract has been shattered. The innocent party is sitting there, disadvantaged, out of pocket, and likely very angry.
Yeah, usually furious.
The law must step in to provide a solution, a remedy, to right the wrong. And by far the most common remedy, the absolute default setting of the common law system, is damages.
Damages. And just to be clear, for anyone new to the terminology, damages simply means money.
Financial compensation ordered by a court.
Right. But I want to pause here because this is vital. Let's look at this conceptually. When we force a breaching party to pay money damages to the innocent party, what is the actual goal?
A very good question to ask.
Are we trying to make the breaching party suffer? Are we punishing them for being a bad corporate citizen and breaking their sacred word?
This is perhaps the most important conceptual leap a law student must make, and it is where lay people completely misunderstand the law.
Okay, lay it on me.
The foundational memory tip for this entire area of law is compensate, not punish.
Compensate, not punish.
The purpose of contract damages is never, ever to punish the contract breaker. Never. If you want to punish someone, if you want retribution for bad behavior, you go to criminal law.
Right. Fines and jail time.
Criminal law uses fines and imprisonment to penalize society's rule breakers. Contract law is completely different. It is purely, coldly economic. It is entirely focused on the innocent party, not the guilty one.
Let's dig deeply into that stark contrast.
Yeah.
Let's say I own a highly profitable commercial bakery.
Okay, I'm getting hungry.
You are a massive agricultural firm, and you supply me with specialized flour every single Monday. We have a 5-year contract.
Got it.
1 week, the market price of flour spikes. You realize you can make more money selling my flour to someone else. You make a deliberate, calculated, purely greedy choice.
I sound terrible.
You call me and say, I'm not delivering your flour, sue me. You intentionally breach the contract. Because of your greed, I can't bake any bread, my shelves are empty, and I lose out on exactly 5,000 pounds of profit that week.
A clear loss.
Now, when I take you to court for damages, I am furious. You betrayed me. I want the court to fine you 50,000 pounds to teach you a lesson so you never do it again.
When the court will absolutely refuse to do that.
But why?
The judge will not care that you were angry, and they will not care that the supplier was greedy.
They won't.
The court will look at your financial spreadsheet and apply the fundamental rule of expectator in damages. The aim is to put the innocent party into the position they would have been in had the contract been properly performed.
Okay, let's trace that logic mathematically. If the contract had been properly performed, if you hadn't been greedy, you would have delivered the flour, I would have paid you the contract price, I would have baked the bread, sold it, and I would have made exactly 5,000 pounds in net profit.
Right.
So my expected position, the alternate universe where you kept your promise, is me being 5,000 pounds richer.
Therefore, the damages the court will award you will be exactly 5,000 pounds.
So it's the 5,000.
Not a penny more for your emotional distress, not a penalty fine for the supplier's bad behavior, just the 5,000 pounds. That money strictly compensates you.
It just fills the hole.
Exactly. It bridges the financial gap between the harsh reality of the breach and the hypothetical world where the contract was fulfilled. The law is essentially trying to construct a financial time machine to put you exactly where you expect it to be.
A financial time machine. I like that.
It has zero interest in making the flour supplier bleed. It only wants to make the baker whole.
I have to be honest, it is so emotionally detached. As human beings, when someone breaks a promise to us, especially for selfish reasons, we feel betrayed.
Of course we do.
We want justice. We want them to feel the sting of their betrayal. We want punitive damages. But contract law says leave your emotions at the door. Let's look at the accounting ledger. It's just math. What did you lose? Here is the money to replace it.
It is entirely detached, and that detachment is very deliberate and necessary.
Why is it necessary?
If we connect this to the bigger picture of a functioning global economy, businesses absolutely require predictability.
Right.
If breaching a contract meant you might face arbitrary, punitive million-pound fines just because a judge thought you acted badly or wanted to teach you a lesson, Commerce would grind to a halt.
The risk of doing business would be too high.
Exactly. No one would sign a contract.
So the law is actively protecting the person who broke the promise.
In a way, yes. It is protecting their ability to calculate risk. By strictly limiting damages to mere compensation, the law allows businesses to engage in what economists call efficient breach.
Efficient breach, what is that?
A company can look at a contract, do the math, realize it is actually cheaper for them to intentionally breach the contract, pay you full compensatory damages for your lost profit, and take a better deal elsewhere.
Wow.
The law allows them to make that ruthless economic choice, because as long as you, the innocent party, get your £5,000 and are made whole, the law considers justice to be served. It's a highly pragmatic, unsentimental system.
Wow. That is a deeply cynical but incredibly realistic way to look at how corporate law actually functions.
It is.
The system accepts that breaches will happen, doesn't judge the morality of it, and just provides a clean mathematical way to clean up the financial mess.
Compensate, not punish.
Exactly.
But moving into situations where that financial time machine breaks down,
yes.
there has to be a limit to that logic, right? Because money can't buy absolutely everything. What happens when cash simply cannot fix the breach?
This is where we step out of the rigid mathematical world of common law damages and into the much more nuanced, flexible world of equity.
Equity.
Sometimes the financial time machine just doesn't work because the thing you lost cannot be bought anywhere else at any price. Let's go back to your very first example, the one we opened with. You have agreed to buy a unique piece of real estate.
Right, that £2 million corner lot in London overlooking the river.
We signed the contract, but you got a better offer, so you breached. You refused to transfer the deed to me.
Now, if we ruthlessly apply the standard common law rule, compensate, not punish, the court would say, okay, the innocent buyer lost the property. What was it worth? $2 million. Let's just give the buyer their £2 million back, maybe some extra for lost time, so they can go buy an equivalent property.
Okay, but what is the fatal flaw in that logic?
You tell me.
The fatal flaw is that there is no equivalent property.
Exactly.
It's a unique corner lot next to a monument. Every single piece of real estate in the world is legally considered unique. You can't just buy the exact same view and location down the street.
You really can't.
I don't want your compensatory damages. I want that specific patch of dirt that I contracted for. No amount of cash can put me in the position I would have been in if the contract was performed, because the only thing that puts me in that position is owning that specific land.
Perfectly reasoned. In situations where damages are fundamentally inadequate to provide justice, the court may reach into its equitable toolbox and order a different remedy called specific performance.
Specific performance. The name kind of gives it away, but let's break down the mechanics of it.
It means the court issues a direct, coercive order compelling the breaching party to actually perform their contractual obligations.
So they force the sale.
In your land example, the judge bangs the gavel, looks at the seller, and says, no, you cannot just pay damages and walk away. You must sign the transfer documents and hand over the deeds of that specific land to the buyer, exactly as you promised. The court actively forces the completion of the contract.
That feels incredibly powerful. The court is actively reaching into your life, seizing your property, and forcing you to do something against your will.
It is very powerful.
But there's a massive flashing warning sign here in the revision materials for exams. It's the difference between common law and equity. Specific performance is an equitable remedy, which means it is entirely discretionary.
Yes.
Wait, so the court doesn't have to grant this? Even if I prove you breached the contract for the land, and I prove I'm innocent, the judge could just shrug and say no.
Yes, and this is a crucial distinction that students must grasp. Damages are a right. If you prove a breach and a financial loss, you are entitled to damages as a matter of absolute legal right.
The judge must give them to me.
The judge must give them to you. Specific performance, however, is a privilege. It is granted at the absolute discretion of the court.
Interesting.
Because it is an equitable remedy, the court will look at all the surrounding circumstances. They will look at the behavior of both parties. Did you, the buyer, act fairly? Have you delayed too long in asking for it? Would forcing the sale cause extreme, disproportionate hardship to a third party?
So they look at the whole picture.
Equity is concerned with fairness. And fundamentally, the court usually will not order specific performance where damages would be an adequate remedy.
So if the contract wasn't for unique land, but was just for 1,000 generic, mass-produced red bricks and the supplier breaches, I can't demand specific performance.
Definitely not.
I can't force them to hand over their specific bricks. The court will just say, don't be ridiculous. Take this damages money and go buy 1,000 identical red bricks from the supplier down the street. Money is perfectly adequate.
Exactly. They save the massive power of specific performance for truly unique items. Land, rare art, antique heirlooms, custom-built machinery, things that cannot be replaced on the open market.
It makes a lot of sense.
And there's another very practical reason courts are incredibly hesitant to order specific performance, particularly for services.
What's that?
It requires supervision.
Ah,
If a court orders a complex commercial builder to specifically perform a contract to build a highly complex architectural structure because they tried to walk off the job, who is going to make sure they do a good job?
right. Who's checking the work?
The judge. The court doesn't have the time or expertise to be constantly inspecting brickwork and plumbing to ensure the forced performance is up to standard.
Yeah, that would be a nightmare.
It is much, much easier for the legal system to just award a chunk of money for damages and walk away. This practical limitation brings us to the flip side of the equitable coin, injunctions.
Right. If specific performance forces you to do something, an injunction usually orders someone not to do something.
Yes. It is typically a negative prohibitive order. A classic commercial example is preventing somebody from breaching a restrictive covenant.
Let's unpack how a restrictive covenant works in practice. Imagine I build up a highly successful accounting business over 20 years. I know all the clients, I have all the goodwill.
You're a staple in the community.
Right. I decide to retire, so I sell the business to you for a massive sum. As part of that contract, I sign a restrictive covenant promising that I will not open a competing accounting firm within a 10-mile radius for the next 3 years.
Which protects the goodwill I just paid for.
Exactly. That clause protects what you just bought. But 6 months later, I get bored of playing golf. I rent an office right across the street, put my name on the door, and start calling my old clients.
Which is a brazen breach of the contract.
I am brazenly breaching it, yeah.
In that situation, you don't necessarily just want damages. Think about how hard it would be to prove damages. How do you accurately calculate exactly how much future profit my new business is stealing from yours day by day, client by client?
That sounds impossible.
It's totally speculative. It's an accounting nightmare. Instead of waiting to bleed money and then suing me, you want me to stop immediately, you would rush to court and apply for an injunction.
And the court steps in.
The court would issue a strict legal order backed by the threat of contempt of court and prison saying to me, do not open that business, take the sign down, stop calling those clients immediately.
It freezes the breach in its tracks before the damage becomes irreversible.
Exactly. But again, you must remember the golden rule of equity. It's discretionary. It is not automatic. The court will weigh what is called the balance of convenience.
The balance of convenience.
Right. Will granting the injunction destroy my livelihood entirely? Is the geographical area too broad? Is 3 years too long? Will it cause disproportionate harm?
So they won't just grant it blindly.
No. If the restrictive covenant is deemed unreasonable, the court will refuse the injunction and let me keep competing, leaving you to try and claim damages. Equity is all about balancing the scales of fairness, not just blindly applying rigid rules.
Okay, this brings us to the final massive hurdle for the innocent party. We've talked about damages, specific performance, injunctions. It sounds like the innocent victim of a breach holds all the cards.
It does, doesn't it?
But the reality is that the law doesn't just hand the victim a blank check to ruin the breaching party. The law places strict limits on these remedies to ensure economic fairness and prevent victims from exploiting a breach.
Very strict limits.
The first major limitation is a favorite principle for SQE examiners: mitigation of loss.
Mitigation is fundamentally about economic efficiency and basic common sense. The legal principle is that the innocent party cannot simply sit back, allow their losses to passively grow and accumulate, and then expect the breaching party to foot the massive bill at the end.
You can't just watch it burn.
No. The victim has a positive legal duty to take reasonable steps to reduce or mitigate their own losses.
Let's go back to my bakery scenario because it illustrates this perfectly.
Yeah.
You are my flour supplier. You breach the contract. You call me on Monday morning and say, I'm not delivering the flour this week.
Now, as the innocent victim, what is your first instinct? You might think, great, I'll just send all my bakers home on full pay, shut the shop down for the entire week, lose 10,000 pounds in sales, and then sue the supplier for every single penny of that 10,000 pounds because it's their fault.
Right. I'm the victim. Why should I have to work hard to fix your mess?
Exactly.
But the law says I can't do that. I have a duty to mitigate. I have a phone. I have the internet. I need to spend Monday morning calling other agricultural suppliers, wholesalers, even local supermarkets.
You have to try.
Even if the replacement flour is more expensive, I have to try and get it so I can keep my bakery ovens running, sell bread, and minimize the overall financial damage. The memory tip to keep in mind here is help yourself first.
Help yourself first. I love that phrasing because it perfectly captures the court's attitude. The law expects reasonable, proactive commercial behavior even from victims.
Okay, but what if I try and it still costs me?
Now, if you do find replacement flour, but because it was a last-minute emergency order, it costs you an extra 500 pounds above our contract price, I still have to pay you that 500 pounds in damages.
Oh, because I did my best.
Because you acted reasonably to save the larger profit, you mitigated successfully, but you still suffered a direct loss. However, if you just throw a tantrum, lock the doors, and don't even try to find other flour, the court will artificially reduce your damages.
They will.
Yes. They will look at the market and say, if you had made 3 phone calls, you could have got replacement flour for an extra 500 pounds. Therefore, we are only giving you 500 pounds, not the 10,000 you claim you lost.
Ouch.
You only get what you would have lost if you had acted reasonably.
It's an incredible balancing act. The law aggressively protects the victim's expectation interests, but it also sternly demands that they act logically and commercially. They cannot weaponize the breach to punish the other party by artificially inflating the damages.
Absolutely.
Which leads us to the final and arguably most complex hurdles for claiming damages: causation and remoteness.
Let's tackle causation first, as it is usually more straightforward. The loss claimed by the innocent party must actually, factually, have been caused by the breach of contract.
Meaning?
If the loss would have happened anyway, regardless of the breach, it is not recoverable.
So if you failed to deliver the flour on Monday, but it turns out that on Sunday night, a massive electrical surge completely destroyed all my bakery ovens, meaning I couldn't have baked bread on Monday anyway, your breach didn't actually cause my loss of profit.
Exactly.
Broken ovens did. Even if you had delivered the flour, it would have just sat there. Therefore, I can't claim that lost profit from you.
Exactly. The chain of causation is broken. You suffered a loss and I committed a breach, but the two are not legally linked.
Makes total sense.
But the final concept, remoteness, is where the real intellectual heavy lifting happens in contract law. This is the battleground.
Why is it the battleground?
Because not every single loss that is factually caused by a breach can be claimed. The law has to put a boundary line on liability. Otherwise, a single breached contract could make someone liable for an infinite chain reaction of economic disasters.
Okay, so where's the line?
That boundary line is determined by the test of remoteness. The foundational rule stems from a famous 19th century case, and it dictates that you can only recover losses that are reasonably foreseeable.
Reasonably foreseeable. That is a phrase that pays the bills for thousands of lawyers. Let's use your catchphrase here. This raises an important question. Whose foresight are we talking about? And critically, when are they supposed to be foreseeing it?
The timing is everything. The memory tip you must drill into your head is, could the parties reasonably have predicted this specific type of loss when they made the contract?
When they made it, not when it broke.
Exactly. We are not looking at what is foreseeable at the time of the breach, when everything is falling apart. We are traveling back in time. We are looking at the exact moment the contract was signed.
Okay, so we're looking at the start of the relationship.
When you and I sat across the table, shook hands, and signed that paper, could we, as reasonable commercial actors, armed with the knowledge we had at that exact moment, have predicted that this specific type of loss would result if things went wrong?
Let me try a wild, high-stakes example to really test the limits of this, because this is where exams love to trick you.
Go ahead.
I own a massive manufacturing factory. I hire a standard courier company to deliver a specialized replacement gear to my factory by tomorrow morning. I pay them the standard 50-pound overnight delivery fee.
Seems like a normal transaction.
The courier messes up, they put it on the wrong truck, and they delay the delivery by an entire week. Clear breach of contract.
Very clear.
But here is the catch. Because that one specific gear was missing, my main assembly line couldn't run. My entire factory had to shut down for a week.
Oh, wow.
Because we shut down, I missed the deadline on a massive once-in-a-lifetime government contract, and I lost £1 million in guaranteed profit.
A catastrophic loss.
Factually, the courier's delay absolutely caused the loss of the £1 million contract. But is it too remote? Can I sue the courier for £1 million over a £50 delivery fee?
This is the perfect classic exam scenario, mirroring the famous case of Hadley v. Baxendale.
Okay, so what does the court say?
The court asks the time travel question. When the courier accepted that package and your £50, did they know, or should they reasonably have known, that a delay would cost you $1 million?
Probably not.
Unless you explicitly, specifically told them at the time of contracting, listen carefully, this is the most important gear in the world, my entire factory relies on it, and if it's one day late, I lose a £1 million government contract. Unless you imparted that special knowledge to them, they couldn't possibly foresee that massive loss.
Right, they're just a delivery guy.
They are just a courier. They transport thousands of generic boxes a day. To them, it was just a metal part. The massive, catastrophic loss of government contract was completely unforeseeable to them at the time they made the deal. It is too remote.
So I can't claim the $1 million. Even though their mistake literally ruined my business, what can I claim?
You can only claim the normal, predictable, direct losses that arise naturally in the ordinary course of things. Perhaps the cost of hiring a temporary, slower backup machine for a week, or the cost of paying your idle workers for a few hours while you sourced a local replacement part.
But not the $1 million.
Not the $1 million. The law aggressively protects the breaching party from being hit with catastrophic, unpredictable liabilities that they never, ever agreed to risk when they took the job.
And that makes perfect economic sense. If the courier had known there was a £1 million risk attached to a late delivery, they never would have charged you £50.
Exactly.
They would have charged you £10,000 to cover their insurance, or they would have flat out refused the job because it was way too risky.
Precisely.
Remoteness ensures that parties are only held legally liable for the scope of risk they implicitly accepted when forming the contract. If you have a special, highly vulnerable situation, it is your duty to communicate that risk before you sign, bringing it into the realm of foreseeability.
Exactly. You must bring the special circumstances to their attention at the time of formation. If you don't, the loss remains too remote.
This brings us beautifully to the final stage of our deep dive, the master strategy.
Ah, yes, bringing it all together.
We have spent an hour exploring all these scattered, highly complex pieces of the legal puzzle. Discharge, exact performance, the harshness of frustration, the mini-contract of variation, the detachment of damages, the power of equity, mitigation, and the boundary line of remoteness.
It's a lot to wrap your head around.
It really is. Now, we need to assemble them into a logical, usable framework, especially for anyone listening who is preparing to sit an exam like the SQE, because knowing the rules is useless if you apply them in the wrong order.
Yes. Legal knowledge without structural logic is just trivia. You need a methodology.
Okay, what is the strategy?
The most valuable piece of strategic advice for navigating any contract law problem, whether in an exam or in practice, is understanding the order of operation.
The order of operations.
When you face a complex factual scenario, a venue burning down, a supplier going rogue, a buyer refusing to pay, human nature, and certainly student nature, is to immediately look at the person who lost money and jump straight to calculating remedies. You see a victim, and you want to calculate their damages.
It's the most exciting part. You want to figure out who owes who £1 million, but that is a trap, isn't it?
It is a fatal trap. You must never jump straight to remedies. You must force your brain to follow the structural logic of the law, step by sequential step.
Okay, let's lay out the steps. Step 1.
Step 1. Has the contract actually ended? Is it discharged? You must first analyze if the obligations are still alive. Did they perform exactly? Did they mutually agree to walk away?
Step 2.
Step 2. If the contract is discharged, how did it end? Was it frustrated by an unforeseeable event that was no one's fault, wiping the slate clean? Or was it a breach where someone actively failed to perform?
Step 3.
Step 3. Only once you have firmly established that a legal breach has occurred and that the contract hasn't been validly varied with a mini-contract, do you move on to what remedy is available.
That's when you look at the money.
Exactly. You ask, are damages adequate? Do we need equity? And then you aggressively apply the filters of mitigation. Did they help themselves first? And remoteness, was the loss reasonably foreseeable when the contract was signed? Wow.
That strict step-by-step logic is exactly how you demonstrate sophisticated legal thinking. That is how you earn the marks. You have to build the foundation before you inspect the roof.
Build the foundation before you inspect the roof. I love that. Start at discharge, end at remoteness. And that structural advice brings us to the end of our massive contract law revision series.
We made it.
Over these deep dives, we have covered the entire sprawling life cycle of an agreement. We built the ship with formation, offer, and acceptance and consideration. We charted the course with terms and exclusion clauses. We looked at the storms of vitiating factors and misrepresentation. And today, we handled the grand finale of discharge, variation, and remedies.
It is a massive intellectual edifice. It can feel overwhelming. But I hope we've shown today that beneath the archaic, complex terminology, contract law is ultimately just a formalized, highly evolved system of human logic. It is constantly trying to balance basic fairness, commercial predictability, and economic efficiency. If these deep dives have helped make contract law feel a little less intimidating, a bit more logical, and deeply connected to the reality of how the world actually works, then that's exactly what we hope to achieve.
Absolutely.
But before we go, I want to leave you, the listener, with a final provocative thought to ponder. Something to chew on that builds on what we discussed today, specifically regarding that incredibly complex concept of remoteness and reasonably foreseeable losses.
It is perhaps the most vulnerable, heavily tested pressure point in modern contract law.
Think about it. The rule of remoteness was designed in the 19th century in an era of steamships and telegrams. But we live in a hyper-connected, fast-moving, incredibly fragile global economy.
We do indeed.
Decades ago, if a blacksmith was late delivering a horseshoe, the most foreseeable loss was maybe a delayed wagon delivery to the next town. It was contained.
Right.
Today, a single tiny software glitch in a minor third-party app or a single cargo ship getting stuck sideways in a canal can literally shut down entire industries worldwide within a matter of hours.
It's terrifying when you think about it.
Supply chains are so intricate, so tightly wound, that a tiny, seemingly insignificant breach in one obscure contract can cascade into billions of dollars of damage across the globe. So in that environment, what does it actually mean to reasonably predict a loss at the very moment a contract is made?
It's almost impossible.
Can any human being or any algorithm truly foresee the cascading butterfly effect of a modern commercial breach? As the world gets more and more complex, the historical legal definition of what is foreseeable might just become the most heavily fought, highest-stakes battleground in the entire future of commercial litigation.
That is a brilliant and terrifying question to leave them with. The law will absolutely have to adapt its 19th century logic to a 21st century reality where everything is connected and a single broken promise is potentially catastrophic.
Something to mull over while you review your notes and build your legal foundation. Good luck with your SQE1 revision. Thank you so much for exploring this vast terrain of knowledge with us, and we will see you next time as we dive into another stack of material.